So we move forward from an insightful session on appeals, penalties, and prosecution. We move ahead with session on faceless assessments by none other than Dr. Pushpinder Puniha, retired Principal Chief Commissioner. Welcome, Dr. Puniha. So Dr. Pushpinder Puniha belongs to 1985 batch of the IRS. He was the national head of the Faceless Scheme and is the senior advisor of finance and taxation of BCCI after retirement. So we are glad to have you on board.
Thank you, Ridhima, for this great opportunity, and thank you, Taxmann. I'm humbled to participate in a forum where such distinguished panelists are participating. And I particularly respect those who are participating. I always have believed in the wisdom of numbers, wisdom of a layman, wisdom of a common man. What they bring on table is what makes the so-called experts like most of us here learn more, to think more, and to gain some insight into it. So as Mukesh Bhai had put it, I am using this opportunity to share a few ideas with you with the aim that I would at least evoke in you a degree of curiosity, so all of us can combine our experiences, our wisdom, our domain knowledge to evolve the faceless scheme into a truly outstanding and painless way of tax administration in the country. Let me start with a bit of a humorous anecdote, which is insightful at the same time. I have a friend from my student days who's very literate and has a very impish sense of humor. So when I was heading the national faceless mission of I call it a mission, in fact, of the country, he told me that, it is so strange. COVID and faceless assessment has taken the charm out of life. And he quoted to me the Benjamin Franklin's old idiom that in this world, nothing can be certain other than death and taxes. He said the certainty of death has been taken away by a non-living virus. And the certainty of that devil across the table who used to tax me has been taken away by all of you by making it faceless. Yeah. So we are, in a way, he was implying that we are being pushed into an uncertain kind of a situation. And my response to him was that you are mistaken in that. We would come out much better once we learn to implement the scheme the way it is conceptualized. So my idea again today is that I would first try and put the faceless assessment scheme in the true context in which it needs to be examined, because it is my firm belief that unlike a lot of people who talk about the faceless assessment scheme that has been suddenly introduced, it is a part of a much larger paradigm shift, which is taking place not just in tax administration, but the way we organize economic activity in the world. Yeah. And I'm referring here to a move away from a relational trust to a transactional trust. Now, you may ask me, what is this? Now, our tax administration is based from what came from the British times. And that was that you have a local fixed jurisdictional officer with whom you interact. Since he has local knowledge and information about you, he will fix your tax liability and you will pay your taxes accordingly. This can be visualized as a kind of a relational trust, where he has some information about me and I go and try and convince him that this is what my actual tax liability is. He applies the law, he applies his local knowledge, and convince him of righteousness of my transactions and my books of account. So you can move to the next slide so we can see. So what I was saying is that we are moving to a kind of a totally different system which is based on a transactional trust. And transactional trust is where we don't have to have any kind of a relation, but we rely on information. We rely on the digital media. We rely on artificial intelligence to come to what is my actual correct income. So what I'm trying to say is that faceless assessment system is here to stay because it is part of a much larger paradigm shift. And if I may take it, in fact, further.
So one second, sorry to interrupt. The screen shared is not visible, sir. I think the shared screen process has to go again.
Pardon me, come again? The screen is not coming?
Yeah, we cannot see the people.
Okay, doesn't matter. Let him. Aditya is assisting me. He will put it up the screen. I can carry on. So,
so you may. We are able to share the screen. Thank you.
Okay. So what I'm trying to say is that, in fact, where the faceless assessment scheme needs to be seen is what, in a broader perspective, is what is happening in the adoption of blockchain technology and all the discussion which is going on about Bitcoin and all. If you read Satoshi Nakamoto's original piece, which is the basic theoretical foundation of Bitcoin, and it says the electronic payment system based on cryptographic proof instead of trust. So what I'm saying is that faceless assessment scheme, by relying on digital data, on voluntary compliance, is actually a movement to cryptographic proof instead of what was the relational trust-based, what used to happen before. And what is this cryptographic proof? This cryptographic proof lies in the data sets which the authorities are picking up over the time about the taxpayers, and then making an estimate of what is the embedded income in it. So now, what is the genesis of it? And why am I stating that it will stay forever, in my opinion, is that first, let's see where it comes from. It comes from a very thought about interaction which Honorable Prime Minister had when he addressed all the senior revenue officers in 2016 and 2017. And there he made it very clear in his address that we have to make tax administration anonymous. We have to use technology, and we have to make sure that due course of law prevails rather than the personal prejudices. So this is the kind of thinking which is behind the faceless assessment scheme, that we have to take away the biases as well as any kind of interpersonal relationships which we may have in framing of the assessments. Can I have the next slide? And if I may say so, how it is going to play out is, when he introduced the faceless scheme throughout India in August 2020, Honorable Prime Minister took equal amount of time to say that what we are doing with this is actually bringing about a transparent taxation, and by honoring the honest. By honoring the honest, he placed a great emphasis on the voluntary compliance by the taxpayers. So another feature of the faceless assessment scheme, which I'm trying to emphasize, is that it is based on digitization. It is based on collection of financial information by the Income Tax Department, and then, very importantly, on voluntary compliance by the taxpayer, where as advised by the experts, all the chartered accountants, the financial consultants, and the advocates with the taxpayers. And how it will play out, I thought was very, very aptly summed by the Revenue Secretary when he responded to the budget of 2022. And I'm quoting, if you can read my slides out there, that what we are telling now is, people, that we have information about you. We are expecting you to comply with that information. And if you do not, then we will come up to you. And this is reflected in one thing which Mukesh Bhai also referred to, is this kind of a revolutionary change, which is our annual information statement, which is visible to the taxpayer before filing of the tax return. So the tax department is collecting a lot of financial data as the information is now digital, and then it is sharing it with the taxpayers, so that before filing the tax return, you have a clear idea of what is known about me, and I respond accordingly. And to an extent, again, I'm reverting back to the amendment which Mukesh Bhai was emphasizing. It reads very well into an opportunity being given to the taxpayers now to revise their return for a much longer period by paying a certain extra amount in case they missed out something in their original filing. So my idea is that voluntary compliance is one of the bedrocks of the faceless assessment scheme. So now with this background, let me go to the kind of change which it requires from you and me. And then I will come to the specifics, how the current Finance Act meets those requirements. Now, the first issue which we need is that, look, now it is, since no longer relational, all the emphasis is on my writing skills, how well I can portray to the tax officer who is anonymous that what is reflected in my accounting statement and tax return is correct and true. And that can happen only if I have the capacity of having very clear, concise writing skills. So what I am suggesting to my taxpayer brothers and sisters and to my professional brothers and sisters is that the need of the hour is that let's try and improve our writing skills. Let's try and put in writing the same clarity which I previously sought through a verbal interaction or by reading the body language of the tax officers or so. So that is one skill set which I would recommend that all of us need to learn as we move into the faceless assessment paradigm and make it as a part of our every year routine. Now, for the tax administrator, it also calls for a new skill set. That skill set is, how do I interpret the financial transactions data and estimate the income which is embedded in it? That is what we call in our parlance the risk analysis. And we are constantly evolving on the risk analysis. What are the criteria? What are the best practices of the risk analysis, so that we pick up only those cases for e-verification and scrutiny where the risk analysis criteria clearly says that the financial transactions data available with us is not reflected in the income of the taxpayer. So with these words, I'm again summing up what I have said till now, that faceless assessment regime is here to stay. It is a part of a much larger paradigm shift towards from a relational to a transactional trust. It is based on voluntary compliance. It is based on digitization, which has taken place in the country, and collection of that data, presenting it to the taxpayer prior to the filing of the return, so that the tax return filed itself reflects the true and correct income. With these words, now let me come down to what the problems which, when we introduce this scheme, any new thing which you introduce will have lots of issues and problems. So the Finance Act 2022, right in the memorandum of explains very clearly that what, if I may read the words from there, it says that it is aimed, the whole amendments are aimed to address the various legal and procedural problems which are being faced in the implementation of this scheme. And a lot of litigation has taken place on that. We have learned from interaction with the taxpayers, with the professionals, what are the problems coming. Those problems were primarily relating to, yes, we had information technology glitches. We had orders which we had passed before giving a proper opportunity to the SSE. We had made promises that no draft assessment order, no order will be passed unless and until a draft assessment order is served on the taxpayers. It means we would provide sufficient means and measures by which the principles of natural justice can be built. But a lot of litigation and a lot of interactions have shown to us that this has not happened. We, from the tax department side, at times failed to provide sufficient opportunity to the taxpayers. We did not give them the draft assessment orders, which had differences from what they had returned in their income. So this led to a lot of litigation. So the main amendments which are being brought about are aimed to address those problems which have come before us through the judicial forums, as well as through the interaction which has taken place, to which Mukesh Bhaiji referred in his opening remarks. Now, what are these amendments? Now, let me take you down through some of these, like which will show us how they are. Like, now, can I have the next slide, please? So now, and then how's our time going? Let me move it on. So what we have is that we have substituted the old section 144B from clauses 1 to 8 by a new provisions. Now these new provisions are what? Like in 144B1, we have primarily laid down before the taxpayers in very clear terms the breakdown of how the assessment takes place in the back room. How from an individual assessing officer, we have gone to an assessment unit, which has now been defined very clearly to have the same powers as an assessing officer. How the verification unit's functionality comes into play. How is the technical unit there to provide us the guidance at all? How we will keep the faceless assessment scheme also open to the dispute resolution panel. How we will give an opportunity to have special audit done in cases where the need so arises. So this is where in 144B1 now, we have the clarity about the backroom operations, though the interface of the taxpayer will only be with the NFSAC, but what are the backroom operations and what is their role has been clearly laid out for the taxpayer and for the professionals. Now, I would particularly invite your attention here to 144B3(4), which is the technical unit, and this kind of reads into what my predecessor panelist was talking about the dispute resolution. Now, the dispute resolution is a very major part of the scheme itself, and the scheme itself provides for a technical unit. Aditya, if you will take the 144B3, where technical unit is defined. Now, technical unit has been devised to provide legal aid by accounting detail to the assessment unit. The purpose of technical unit is that it will be a kind of an advisory to the assessment unit where complicated legal or accountant practices arise. Now, the idea behind it is that technical units, and 4 technical units have already been established to deal with 4 different regions of the country, that they will take into account all the emerging disputes, all the emerging issues of that area, and try and evolve a consensus on those issues, and to convey that consensus to the assessment unit so that we do not have repetitive kind of litigation taking place. So my idea here is, and I have a suggestion which I said that all of us can use this forum to talk about it, is that the technical units as of now, to the best of my knowledge and understanding, is constituted by the departmental offices. If we really have to make the faceless assessment scheme truly a means of reducing litigation, then we need to think about reconstituting the technical unit. So the technical unit can have inputs from, say, Institute of Chartered Accountants, from, say, the Ministry of Legal Affairs, Law and Justice, so that any emerging dispute, which may be an accounting standard related, which may be legal, a consensus can be evolved so that that consensus may be pro the taxpayers or maybe pro the department, but at least one position clearly emerges. So my point for all of you to discuss is that let's try and evolve a kind of a consensus that what kind of a technical unit can we evolve which represents all shades of opinion and views, how those opinions and views can be articulated, and how those views can then be represented in the assessment orders and can become a basis of bringing the repeated disputes which take place to an early conclusion. And this is something which, when the architecture of the faceless scheme was being thought about, was debated at length. But I think we need to start talking about building this into a much broader forum of consensus on issues, because as most of us are aware, most of the litigation which arises in the income tax department relates to few issues. And if we can identify about 20 of those issues, about 85 to 87% data set at that time showed of litigation can be summarized within those 20 issues, which are both accounting and legal. So if we can draw a consensus on those 18 or 20 issues, then we can have a tremendous ease of doing business and have certainty about our tax liability. So my suggestion to this, through this highly talented and learned forum, is that let's try and evolve a very representative technical unit which solves our litigation problem and gives us a certainty about the tax liability as early as possible. And in the long run, it fulfills the aim which our Honorable Prime Minister has repeatedly mentioned, is towards drawing those laws and that administrative structure which provides for ease of doing business. So this is one substantive issue which I would like to put up before all of you for discussion. Now, the other change which these amendments have brought about are also significant. One is that they have very clearly made one team of officers responsible and accountable for the decisions. That is the purpose why the assessment unit has now been defined as assessing authority for all practical purposes and legal purposes of the Act. So now, once the accountability and the responsibility is fixed, then if God forbid people take actions, people still go for those kinds of questioning and decision making which does not fit into the purview of the faceless assessment scheme, then those persons can be held accountable and suitable action within the administrative hierarchy of the finance ministry can be taken against them. It is not meant to punish anybody, but it is meant to bring accountability and responsibility in the actions of the departmental officers, who, after all, by fixing additional tax liability on any taxpayer, cost huge amount of both money and resources on both sides, both from the government side, from the state side, as well as from the taxpayer side, because a litigation is a time-consuming, energy-sapping, and financially costly affair. So this is why at number of places you would find the digital signatures of those persons who are a part of the assessment unit, as well as the identification of those persons which are not visible to the taxpayers, but administratively their responsibility and accountability can be fixed. And I think it is again a very positive and a development which the new amendments have taken in terms of accountability and all. So now there were a few other issues which are according to me very, very important. One is that there was a confusion about, what is at when and how can I get a hearing, a personal hearing. The personal hearing in the faceless regime is nothing but through the video conference, through an electronic or a digital interface. But when can I get it? When do I get it if I ask for it? Is it my inherent right as principles of natural justice to get a hearing? So there was a lot of confusion, a lot of litigation also on this. Now, this has been made clear by bringing the amendment where the video conference facility shall be provided to any assessee who asks for it. And once again, I think it is a very positive development. I should not be denied an access to a medium of representation, which constitutes an important part of what is the principles of natural justice as it has been understood over so many years by various judicial forums as well as by a layman. So this is a positive development where, as a matter of right, I can ask for a video conference facility, a personal hearing through video conference, and I will have the satisfaction of representing my point of view, canvassing my point of view before the assessment unit. And in fact, here I had talked about one skill set which the taxpayers and the professionals need to learn, which was of critical writing. And I had talked about one skill set which the departmental officials need to do is to how to fine-tune the risk analysis and how to calculate income out of the financial transactions which is embedded in it. For video conferencing, I may suggest something which may sound outlandish, but I would suggest, at least to my professional brothers and sisters, take a course in theater. Learn how to portray a positive energy or positivity when you are interacting across a virtual medium. And as and when I go for my training lectures, I normally talk about that. Look at a screen set. When you go into a cinema, you see Salman Khan in Ekta Tiger. When he comes to a screen, he's a small statured man, but he fills up the screen and you feel that he can bash up all the villains. And then you have Ayushmann Khurrana in something like in a movie in which Shubmangal Savdan, what was it? Yeah. So in which, how is he? He's a bigger man with a physical presence, but he still looks very submissive, open to question, vulnerable. So as and when you are in a virtual medium, it matters. Your convincing power would be so much better if you know how to portray what energy do I need at this particular moment. There might be that, in a video conference, a point which is absolutely wrong has been portrayed and you've been questioned about it. It may be that you need to give Salman Khan kind of energy there and say, no, look, I am correct. And here is the proof. But there may be situations where it is like, it's an iffy situation. Why not portray that little vulnerability and that, yes, I am little doubt, but this is how I'm trying to convince you. This is the view I convey. So why don't you agree with me? So what I'm suggesting is that in a faceless assessment regime where everything is going virtual, it is so much important to convey what we used to convey across the table through the digital medium. And for that, it is very important to learn those theatrical skills by which I can have a greater power of conviction. So my open kind of an advice to the youngsters is, please learn how to look convincing in a kind of a digital forum, and it can take you much further so how are we placing time here? Like, yeah. So now let me come down again to the things which I find that maybe the change amendments could have avoided it or shouldn't have been done in this manner. This is that we are averse or ought to be averse to bringing any change which is retrospective. And we have kind of made it that, you know, the issue of all those judicial judgments which found fault with the process of framing faceless assessments wrong. Now we have the legislature in its wisdom has said that retrospectively that provision under 144B9 stands omitted. So I appreciate that to some extent the loss to revenue was caused by these appeals because the information technology of the department was not up to the standards it was required to be, or we as the departmental officers did not have the suitable training and did not fulfill the scheme in letter and spirit. And various high courts and the judicial forums have held that those assessments are not valid. We have gone for a retrospective amendment. I would have much preferred if instead of the retrospective amendment, we would have ignored that. It is like as in economics and statistics, of which I'm a student also, it is like a noise in data. The noise in data needs to be ignored. It was a cost of process of a huge and a very beneficial change, I think, which this government has brought about. So we could have digested that cost and moved on, because retrospective amendments disturb what again is the vision of our Honorable Prime Minister, that we must have certainty of the law, we must have ease of doing business, and I should not be harassed by changes in those things which I thought were settled. So I was for all the positive things which have been brought about, this amendment disappointed me a little. So I'm putting this in forum so that again we have a chance to look at it. Was there a better way of dealing with it than what has been done by the legislature for bringing about this change? Now, the last point which I want to make is that the changes which have been brought about very clearly also show us the progressive path where we are headed. The data when I was working with in the Faceless Assessment Center showed us that, you know, our contact with the taxpayer through the emails, through the portal, left a lot to be desired. Because a lot of people do not access their emails, a lot of people and even professionals don't go to the portal as often as they go. Now what the Act is providing is that we would even provide the information on the mobile phone. So in a way, it is wonderful because we are reaching to the taxpayers, exchanging information on a medium which is most frequently used by the taxpayers. So if you would read the amendment, It says that as we move forward, the real-time alerts would be coming to the taxpayers on their mobiles also, and mobile application would provide all the information which the department has relating to a particular issue. So now this is a very positive and a good development, as it brings a more alive, more timely, more contemporaneous interaction between taxpayers and the tax administrator. And that is one of the fundamental beliefs of the faceless assessment scheme, that we can increase the tax collection primarily through voluntary compliance by the taxpayers. We can facilitate the taxpayers for voluntary compliance by sharing more and more data with them, so that even if by omission, by an honest omission, they were going to miss out on some information, we upfront provide it to them so that they take into account when they are filing their tax returns. So I think a movement towards the mobile application, real-time alerts, also shows the kind of technological leaps which the department is taking, and it is also showing us how alive the department is to the real-time problems which are coming from the to the taxpayer, because they don't access their emails on time, or there is a gap between the information reaching the taxpayer and the reply demanded by the department. So I think that is a very, very positive development which is there in these amendments. So let me end by again summing up. Let me sum up that let's be very clear in our mind. Faceless assessment regime is here to stay. It is not going to go anywhere. It is a part of a huge paradigm shift which is taking place in tax administration and in other areas, as I give you an example of the Bitcoins and the blockchain technology. It is based primarily on voluntary compliance. And you and I are already seeing results of that in the current year's tax collection, even when the pandemic is still persisting. Our tax collections, our indirect taxes are exceeding our budget target. To a large extent, it is a reflection of that. If you let the taxpayers know what we know about them, the voluntary compliance would be much higher from them. And what I'm suggesting is that through changes like real-time alerts, changing through the technical unit, as I've proposed, that let's make it much broader, consensus-based, we would be achieving the target of reducing the litigation and fulfilling the aim, which is reduce the cost of compliance, reduce repeated litigation, and improve the ease of doing business for all the persons who are creating economic activity and jobs in our country. Thank you so much. And I have my email on record. I would appreciate any one of you interacting with me on these issues. And I hope to learn much more from you so that we all work together collaboratively to make this faceless scheme more seamless, more tax-friendly, and in a way that it fulfills what in the old times Kautilya has said in our Shastra, that the tax administrators would collect the tax in a manner the bee collects the pollen from the flowers. It, in fact, helps the flowers by passing on the germination. It does not cause any injury to the flower. So let's resolve for that. And I'm sure, again, I take the positivity from Mukesh Bhai, and I believe in that nischay kar apni jeet karo. If we have the belief in us, if we have the belief in the system which we have created, then we are going to emerge victors. Thank you so much.
Thank you, sir. Sir, before you take leave, can I have some time to ask few questions by our attendees?
Yes, of course. Please go ahead.
So one is from Mayank Monaka. He says, why subsection 9 of 144B was proposed to be omitted? In continuation, he has also asked, even if subsection 9 of section 144B has been proposed to be omitted, but then also faceless assessments made against the principle of natural justice, say without issuing the mandatory show cause notice, are liable to be set aside because principle of natural justice is principle of common law. Is his understanding correct?
I think Mayank is articulating a concern which is absolutely core to this whole discussion. And I'm totally with him. Principle of natural justice is a bedrock of any tax assessment system. It cannot be violated under any circumstances. And let's think of it. We are a democracy. I cannot make anyone liable for any additional financial liability unless and until I give an adequate opportunity to that person to explain that what he or she is stating is the correct state of affairs. So I think, Mike, you are absolutely right. This retrospective amendment will not really help the revenue in those cases where there has been a clear violation of principle of natural justice. And in fact, if you read the reasons given in the memorandum why this retrospective amendment has taken, they are basically talking of all those cases where egregious things happened because of the technological problems, not for the principles of natural justice. So some technological glitches also have caused some judicial fora to hold against the department. So maybe this is a way of department of accepting our problems that we had in the transition, technological glitches, and because of those technological glitches, at least we should get an opportunity of bringing the correct amount to tax. So I agree with you. And I think the intention of the legislature is not to deny the principles of natural justice. In fact, that is made more or less clear by making the video conference facility mandatory for all the future proceedings. But it is to take into like kind of forgive those जो लिखते नहीं होते थे हम भूल चूक लेनी देनी. So भूल चूक लेनी देनी हो गई है हमारे से क्योंकि हमारी technology could not keep up with the pace of change. So those cases, at least the department should be given an opportunity to bring to tax. That is what my understanding.
Thank you. I hope, Mayank, your query is answered. Just a couple of more, sir. There's one from Ritu Gupta. She's asking, what will be the fate of ruling decided by the courts after the omission of subsection 9 with retro effect?
Yeah, I think so. I mean, there is, I mean, no, there is again, like, I'm again going back to our basic democratic principles. There is a clear distinction in the roles of the executive, judicial, and legislation. So the judiciary's independence and their power would be respected, and it is always respected. So there is nothing like that they are going to be like, I mean, as if they are non-est. It is nothing like that. So I'm saying is the way forward, the way I look at it, it will be limited to those cases where the technical glitches cause the revenue loss. Those will be taken care of, but not where there is a clear violation of principles of natural justice. Those judgments, I'm sure, will stand, and the division of power between judiciary, legislative, and executive is always appreciated, and it is always upheld by the higher judicial forum as well as by the wisdom of the legislature.
Correct. And last one, so what are your thoughts as to how far is the department ready to ensure that just orders are passed? Are they made tech savvy and learn to handle geographical business barriers?
That's a very good question. This is something which I should have maybe dealt a little more in my talk. You know, it is very easy to at times bring about a change, and it's a radical change according to me. And it is very difficult to build up all the institutions and processes to implement it. And I must compliment that the department has taken a lot of very proactive steps so that we are in a position to act. Let's face it, why do you think so? We have brought about a complete change in the law from what it existed only 1 year ago. It is because problems were being faced both from the taxpayer side as well as from the departmental side. So to overcome those problems which came in implementation, this change has been brought about. Simultaneously, I must tell you that there is a huge emphasis in the setup, learn the skill set which is necessary. First of all, the hardware has to be there, and I'm proud to say that the hardware does exist on that. To build up the soft skills to operate those, yes. You know what the problem comes is, and I must take 2 minutes here, is that at times, and I'm not justifying, the delays of any kind. What I learned while my working in the Faceless Assessment Scheme was that software changes are very time consuming. You may want to bring about one simple change, and income tax by any stretch of imagination has no linear causation. One small change has 10 different results and implications. So what we had evolved was, and I'm sharing this with all the due respect to this forum as well as to my colleagues, we had a very robust set of officers who used to look at all the repercussions of any change proposed in terms of software. We used to give it to the software team, which for a smallest of change would require about 4 to 6 weeks to bring about. And then we would run a user application testing, what we call the UAT. When we do UAT, at times what happens is that we find that, oh my goodness, instead of the 10 footprints, there was a minor 11th footprint which we missed out when we gave it to the software team. So the whole process gets repeated again. Right. So it is a time-consuming business. We have wonderful software personnel in our country. We provide the leadership in the world, and I hope we keep getting the best for our assignment as we move forward. Then the less glitches will come. So at times this interface takes time, and I don't blame anybody for it, but taxpayer has every reason to expect better service from me. And it is, he has paid his taxes. Why should he be put through this cost? But unfortunately, this is the price of a radical change. We are moving to a wonderful new regime where it will be far easier to comply with the taxes under the faceless regime. So this is the cost which we have to pay, and please bear with it.
Certainly, sir. Thank you, sir. I think that was a very, very helpful session. And with all those candid examples and suggestions, I think I'll be following them too today for the presentations. Thanks a lot, sir. It was an honor having you.
Thank you. Thank you so much. Thank you very much.